It's Harpreet Singh from Sharon Law Firm. So today I want to continue, and we have almost reached at the end of the sale process where you will get the most important document, which is called a grant deed. So we will learn today about what's this document about, what's the requirement, and how you will get a piece of title for a real estate through this document. So grant deed, basically, it can be any kind of document. The grant deed, technically, if you want to get the title of real estate, you don't need a specific formatted document. If someone just mention, I am transferring this land to so and so person, and this is so and so land, then ultimately that piece of document transfers the property to the grantee, who is the person who owns the property or getting the title. And even we have heard the story, because in law school means we have seen the case where a person just mentioned on a piece of napkin that he is transferring the land to his friend, and this is the particular land, and later he thought it was a joke, but however the court found that it's reasonable to believe, based on a reasonable person standard, that the title to the real property is transferred now. Regardless, it's on napkin. However, you get issues with recording that kind of document or getting any kind of title insurance, but technically you can transfer the property. So let's look at what are the requirements to transfer a title. So any piece of document which you're using as a grant deed, as you know, the word grant just provides, transfers a piece of thing to some other person. So grant is just you're giving it away. So the first important requirement is writing. As I mentioned also earlier in previous videos, that if you want to do a real estate transaction, writing is required, because that's one of the main important thing, and it has been the standard, I think all over all over the world, that if you want to get transfer of a real estate property, you need something in writing which goes to the effect, which should mention the names of the parties, the grantor and who you are transferring to, the name of the grantee, and also some words, some operative words to the effect of grant. You don't need to use just grant. You can use either I'm transferring, grantor, suppose Mr. Smith, Garcia is transferring the property to Larry Garcia, something like that. So you don't need those specific words, but something which would show a reasonable person that you are transferring this property to this grantee. And another important thing is the description of the property, because obviously what you're transferring, that needs to be mentioned in that document, that you're transferring so and so piece of land. So there can be different methods. So one method which is mostly used, it's the legal description, and it's not required because it's complicated. People don't remember a legal description. I don't remember legal description of properties, but still legal description provides you like very exact and specific things in which piece of document or in register this kind of plan or property is located in your county recorder's office. So it just goes very, very technical. But you don't want to, because most of the time people don't know about it. So you can either mention the address, either it's a mailing address or an APN number. So in some kind of way, a reasonable person would be able to identify that, okay, he's talking about so and so property. So some uniqueness about that property either its address, APN number, or ultimately if you have the legal description, that's good. And so the next thing which is required, and maybe you can say it's required, it's not, it's just about what kind of interest you are transferring. So because there are different kind of estates in a real property, either it's a leasehold estate, either it's a life estate, or it's a fee simple estate. So if you don't know about it, don't worry, in future I will do a video on that, so you have some better idea what's a life estate. So basically these are estate which have less than the fee simple estate. The fee simple estate is basically the highest interest you can get in a piece of land. So it's the absolute interest, means, yeah, sure, when you die, the property is not in your name, but it still goes on and on to your successors, and so it lives forever. So basically you can say the fee simple title is, it just lives forever with you or your successors. So by default, if you don't mention, suppose for example, okay, Smith Garcia is transferring this real property so and so at Modesto, California to Larry Smith. So here you didn't mention like what kind of interest Smith Garcia has, who is the grantor in this situation. So by default, law assumes that it's a fee simple estate, or if suppose Smith Garcia only have a life estate, so Smith Garcia is giving away all of his interest. So that's the default. However, you can still give less than fee simple estate. Sometime you want to get a revert back, sometime you want to put the condition, and most of the people do that. If you are giving it to a non-profit for some kind of assistance with to the public, suppose for a hospital, people give that. Okay, if suppose the hospital would be there for so many number of years, then you will get this title, or if it's not there, then you will not get. And there are also different issues attached to that. Either it's issues with the estate laws, and it's becomes more complicated, but I just want to lay you out. So those kind of things can be either interpreted by law as a default fee simple estate, or you can mention what kind of property interest you are transferring. And the execution of the grantor is the most important thing, because if grantor is not signing the document, even suppose signing a document doesn't mean you have to just write your name. It can be anything which a reasonable person can understand that you are intending to transfer this property. So execution by a grantor, it's really important, because then only you would be able to know that, okay, grantor intended to transfer this property to the grantee. And the final most important thing is the delivery. Now, suppose grantor drafted this document, signed it, and later grantor thought, okay, let me see, why not, I will see for a few days, because most of the time it happens with within the family. Maybe some family members are not good with the suppose father, and just father thinks about, okay, let me think about it. He just drafts this piece of document, the so-called grant deed, and he signs it, and he keeps under the drawer and just needs some time to think about it. So the delivery of that grant deed is really important, because unless and until the grantor doesn't deliver that, that doesn't shows the intent of the grantor to transfer this property. So delivery doesn't mean every time you have to provide that document in person to the grantee. Delivery can be done through a third person. Suppose mostly happens in the transactions. You just provide it to the escrow company, you have escrow instructions, And in that escrow instruction, it mentions that, okay, after getting done with these so and so conditions, or getting all the demands from all the lien holders, vendors, and then we will just transfer this deed to the buyer. So that's like a conditional transfer, but that needs to be exact. The grantor should not have some kind of a fuzzy right, okay, whenever I want I can take it back. Then that's not considered a delivery, and that would not be considered a valid deed. So delivery is most important thing, which can also be done through, if suppose you just record that document in county recorder's office. You are just giving notice to the whole world basically that I transfer this property to grantee, and that's considered as also a delivery. And the next important thing is that grantee should accept that grant deed. So again, it's kind of implied when grantee is recording a document with the county recorder's office, and most of the time, like if grantee is getting piece of property, why he will just not accept that. But however, there can be situation, maybe this property have too much liability, maybe there are environmental issues, and like someone just gift it away to you, and you are thinking, okay, I don't need this property, I cannot spend expense to address environmental issues or other kind of liability, so I don't need it. So in those rare situations, you have issues with the acceptance part of the requirement. So these are all the requirements for, you can have any piece of document which can be considered as grant deed. So let's quickly look at, there are a couple of types of deed mostly used in California. There are like several which are used also in other states, but I will only talk about two. One I have already talked about, it's grant deed, which will provide whatever interest the person has and an actual interest. So through grant deed, you can just transfer that. And then there comes a quitclaim deed. So quitclaim deed, it's also a kind of deed. The requirements are the same as normally for a grant deed or any document for transfer of title of real estate. However, the quitclaim deed, what's its purpose? That suppose you have a dispute for a piece of property with your neighbor, and your neighbor is also alleging that I have also some right on this piece of property, and so you just say to your neighbor, okay, I will give you $5,000, $10,000, so give me a quitclaim deed. Probably neighbor's name is not on the piece of property, sometimes it's encroachment or things like that, but still he is asserting right, and so you can get a quitclaim deed. So he's basically saying that I'm releasing whatever interest I have. Sometimes a person may not have a legally vested interest yet, but still he has claim, and so with that he would be able to release his claim and just provide you any and all interest in the property at that particular time. So these are the types of deeds, and in next video I will talk about how a deed can become a voided deed, which is like an invalid deed. So see you in the next video. Thank you.